Hello everybody, hope you're enjoying craft. I tried out the celebrity lookalike thing on the Azure stand earlier and it really doesn't work. Anyway, um, I'm here to talk to you today about GDPR and privacy in general. Now, why Spider-Man? Why privacy Spider-Man? Well, I'm from a parallel universe where people actually care about privacy, and so I'm just visiting for a little while. But like you, I'm a web developer, obviously. Now, this superpower I have, I'm not the only one with this superpower. There are other people that you may be familiar with. Bruce Wayne is Batman, Clark Kent is Superman, and Henry, the mild-mannered janitor, is of course Hong Kong Phooey. These people all have a common superpower that you might not be aware of. It is of course control over their identities. And these days that is something that is really a superpower. Can you imagine Clark Kent keeping his Superman identity secret if both those IDs were on Facebook? It would be impossible. Facebook would be kind of going, well, Clark Kent went into this phone box and Superman came out and we think they're the same person and we know that information forever. So at this point I'm going to exercise my control over my superpower, my identity control, and reveal it to you, partly because seeing out of this thing is actually quite hard. But here we go. So there's a real person in here.
Turning my audio back on. Right, that's better. Now, and it also means I can wear these. Because unfortunately, good eyesight is not one of my superpowers. Now, though these are superheroes, all this stuff applies to normal people as well. And to just imagine these kind of problems, but on a smaller scale, just kind of incrementally eating away at your identity. So what is it that goes into enabling this kind of superpower? Well, really, there are two things that allow you to exercise this kind of control over your personal data, and they are security and privacy. These are not the same thing. They often get grouped together. So what are these two concepts? Well, security can really be defined as three separate things. Commonly, confidentiality, which is making sure that your data can only be accessed by the people that are authorized to do so. Availability, making sure that this data that you've stored is actually present and accessible for the purposes that we want to use it for, and that we preserve its integrity, that we make sure that it's accurate, up-to-date, and uncorrupted. On top of this, we build privacy, and the dictionary definition of this really is freedom from being observed or disturbed. But as far as our role as web developers goes, we can really think of that as being the appropriate use of data. One of the things that's kind of annoying about a lot of the talk about privacy is the presentation of privacy and security as being somehow conflicting, that it's a privacy versus security. That's a false dichotomy. There is no privacy without security, but security doesn't guarantee privacy. You can think of privacy as being almost like a kind of meta-security. You're detailing the reasons why you're storing this data, rather than necessarily the data itself. Quite often, security features are passed off as privacy. A good example of that is the end-to-end encryption in WhatsApp. That's a confidentiality and security feature. It's not a privacy feature. And the reason for that is that they do nothing to hide the metadata. Facebook knows exactly who you're talking to and when, and that in itself is something that you might want to have protected. Very often these things come together in a bad way, and this girl in this quote is from a Netflix movie called Anon, which I thoroughly recommend. This character exercises her identity superpower with something of extreme prejudice. The whole security versus privacy narrative very often equates privacy with a potential for criminality, as in, what have you got to hide? And that's really why I like this quote. It's not that I have something to hide, it's that I have nothing I want you to see. I think that's a really good alternative way of looking at it. And it provides a good counterpoint to the what have you got to hide argument. And security often gets associated with things like government access to citizens' data. And the problems with that became very clear with Edward Snowden's revelations. But there are far more mundane aspects to this that are much more important to us and the people whose data we look after on an everyday basis. We need to remember that data isn't just some abstract substance. It represents people's lives, and how we handle it has real-world implications. And because of that, we have laws. Lots of laws. Now, privacy laws have a long history. Back in 1981, the Council of Europe put together this thing called Convention 108. And this isn't really a law in itself. It's more like a template for building laws. That if you're a country that's thinking about going about implementing some privacy or data protection law, it provides a kind of a framework for how you might structure it and the measures that you might choose. And 50-something countries have built privacy laws based on that Convention 108. And one of those was probably the most significant bit of legislation in the last 25 years, which is the EU's Data Protection Directive from 1995. Now that's nearly 25 years old. And that's pretty much what the entire web has been built under. This directive is a really pretty significant thing. And as it happens, the things that are new in newer laws are actually really quite minor changes relative to that law. So if you were compliant with this law for any time in the last 25 years, you really didn't actually have that much to worry about. Now, notice that this is presented as a data protection thing and not a privacy thing. So because privacy is pitched at a slightly higher level, there are actually additional laws that apply at those higher levels. And in the EU, that's a thing called the Privacy Directive from 2002. And this is otherwise known as the cookie law that everybody hates. Now, so the EU has this good history of some nice, strong legislation that applies to a large number of countries. And in fact, these laws, okay, now the same cannot be said of the USA. The USA has a very poor history of privacy laws. But they also have a long history of having very large companies storing data about EU citizens in the US. And that presented something of a problem. The EU laws have a concept of data adequacy, where if you're a country where you think that data is going to be moved out of the EU to that country, you want to make sure that the laws in the country it's being moved to are at least as good as those in the EU. Now, that's not true of the US. So what they did is they kind of patched around this by making something called the Safe Harbor Agreement in 2000. And under the Safe Harbor Agreement, you can store data on EU citizens in the US, and while it's in the US being stored there, it's still subject to EU law. So this little carve-out provided the protections that were needed to store stuff in the US. However, Edward Snowden came along and showed what the US security services were doing with it, and an Austrian law student called Max Schrems took Facebook to court in Ireland, because Facebook in Europe is based in Ireland. And he said that they were storing his data as a European citizen in Ireland, and they were then transporting it to the US under the protection of the Safe Harbor Agreement. However, because of the overstepping by the US security agencies, clearly the US wasn't holding up their end of the bargain. And as it turned out, the courts agreed with him, and he won, and the Safe Harbor Agreement was struck down. And at that point, it was actually then illegal to store data on EU citizens in the US. Now, that was a really big problem for some companies. However, nobody really got sued over it because they knew that something would come along to replace it, and that something was a thing called Privacy Shield. Now, note that these two laws actually apply to the EEA and not just the EU, so that includes countries like Switzerland and Norway that are not EU members. Now, in the US, there are some privacy laws, but they tend to cover individual markets. Like the HIPAA Act is all about protecting health insurance information. There's the SEPA thing, which is all about protecting data on children. But there is no overall framework. And in that kind of legislative vacuum, a lot of US companies are actually adopting the EU model as ways to implement stuff, and they're saying, you know, we want to handle stuff in an appropriate way, and we're going to base our stuff on the EU's laws rather than actually following the US ones. And Microsoft and Apple have been particularly good about doing that. So the Council of Europe Convention 108 has actually been updated for the first time since 1981, calling it 108 Plus. It's a catchy name. And that's should shortly be ratified completely, and it really brings things up to date. Now, within the EU, there's a group called the Article 29 Working Party, and in May last year, they were disbanded and reformed as the European Data Protection Board. Now, they were responsible for putting together a rather large piece of legislation, which we have come to know as GDPR, the General Data Protection Regulation. Now, the thing that's different about a regulation rather than a directive is that a directive is subject to implementation by each EU member state separately. And because of that, there has been a lot of differences between those implementations. So, for example, the laws in Spain and Germany are much stricter than those in the UK. The UK's Data Protection Act from 1998 is very easy to read and understand. It's well formulated and well written. However, it's also really pretty loose by comparison with what you can get away with in other countries. So GDPR is largely about protecting the rights of the individual, and again, that's very much in contrast to the laws that are in the US, which are mainly about protecting companies, it seems, largely because they can pay the lobbyists more. It tries to address information asymmetry, where companies know lots about you, but you don't really know necessarily much about them or what they're doing with your data. And so GDPR tries to address that. And GDPR has caused lots of upset. So we're seeing descriptions like this, which I found on LinkedIn. And this particularly applies to those that have a long history of essentially data abuse. Suddenly they find that they're getting their market taken away from them. And of course, they're just complaining a lot and whinging. Well, it's like, you chose to do this kind of thing. It's, I don't really have much sympathy. But these measures are exactly what makes the GDPR good for individuals. It may make it hard on the companies, but that's their problem. They're the ones that are benefiting from us. One of the things that's got a lot of press is the fines. Under the previous legislation, the most that a company could get fined was something like 500,000 euros. Now, I saw recently that I think Facebook were fined 50 million euros for something. And somebody pointed out that this represented less than 1 minute of turnover. So they can just treat this as the cost of doing business. They don't have to bother about compliance, because it takes a long time for these court cases to happen and to actually get them off the ground in the first place. Somebody's got to have sufficient budget to actually make them happen. Facebook in Europe is controlled through Ireland, as I mentioned, but Facebook's turnover is larger than the whole GDP of Ireland. You know, they have an awful lot of power. And so these information commissioners, they need sufficient ammunition to be able to go after big companies like that. And so the purpose of these large fines is not to cripple small companies with ridiculous fines. It's to give them sufficient power to go after the people that are actually causing the most problems. The fines that have happened so far, probably the biggest one that's kind of due to happen is the Marriott hotel chain breach that happened last year, I think. They leaked data on 500 million people. That's a lot. And there are rumors that their fine might exceed 800 million euros, which is pretty hefty, but that's yet to be decided. So again, these are big examples. They're big breaches by big companies. They're not the kind of thing that is actually likely to be applied to a small company, if that's something that worries you. Another factor is that some of the information commissioners, I'm particularly picking out the UK here, have been really poor about implementing this stuff. The UK's information commissioner has done some very public attacks on, in particular, Facebook and Cambridge Analytica that have just been total failures. And they really haven't done anything significant that would actually cause a larger number of companies to really pay attention. So they've really failed in their mission to do that. So within the GDPR, there are several roles about who owns what and who does what. The number one most important person is, of course, the data subject. This is the person who the data is about. That's you or me or any other individual. And they are the owner of the data. You own your own data. It's about you. It's your personal data. So a person that manages this is called a data controller. And they're effectively like a caretaker, the manager. They're responsible for what happens to the data that's collected. They're the ones that set the terms that the data subjects need to agree to if they're going to continue to process it. And obviously, the data controller may not be able to handle everything themselves. Now, if you operate a website and you collect personal data on your website, then you are a data controller. And most countries may require you to actually register with your information commissioner as somebody that has that role. So a controller might farm stuff out to a third party, and that third party would be called a data processor. And the legal agreement between the controller and the processor is a thing called a data processing agreement, and they act on behalf of the controller. And there are lots of things that you could count in there. So things like hosting providers, analytics, what we call CDNs. These are all data processors that you're farming stuff out to as the data controller. Now, the problem is here is that data processors are often quite kind of old school in the way they handle data, and they're often very difficult to keep track of. And sometimes they overstep the mark and start taking on some of the things that only the controller should be doing, like asserting ownership over the data. That's a pretty serious thing for them to do. And it's very difficult to stay on top of the things that your processors are doing, largely because those processors are usually free in typical data processing agreements to farm stuff out to other subcontractors, and they might do it to other subcontractors. And so you can get these long chains of responsibility that ultimately the data controller is still responsible for. So how bad can this get? Well, this blue blob here is Wired.com's homepage. All these blue lines coming out represent additional HTTP requests that are being made from that page, and they typically do things like load fonts and scripts and CSS and images, so that's all exactly as you'd expect. But some of those requests go to places which are not the Wired.com domain, they're other domains, and they might be in different locations, subject to different jurisdictions, different laws. They might be off in the wilds of China or somewhere where you don't really have that much control over it. And these things can get really out of hand. And the reason this is looking a bit blurry is that I need to zoom out. This is the full map of what happens when you hit just Wired.com's homepage. That's just a single request. When you visit their homepage, that's what happens. It's insane. As a controller, you are responsible for the combined activities of every single one of these other services. Now, the thing is that a lot of the US-based sites in particular are kind of fine with this status quo, and they are not really that bothered about it because they don't really care that much about your data because they don't have laws there that require them to control it. But this is why quite often they're happier to block visitors from the EU than to actually go and do something about all these people that they're responsible for. Just in case you're interested in the numbers, that page loads 479 requests to 157 different domains, loading 8.5 megabytes of data and setting 194 cookies. That's completely nuts. Not surprisingly, it also takes forever to load, especially on mobiles. That's really not a good way of building a page. It's entirely possible, of course, to build a site that doesn't use any third parties at all. I know, because that's what I do. So what's inside GDPR? Fundamentally, there are a set of data protection principles. And there are 6 of these. They're covered in GDPR's Article 5. The first of these is pretty obvious. Processing must be lawful, fair, and transparent. That's obviously, you're not allowed to do stuff that's illegal. When you collect data, you need to collect and process that data for specific, explicitly stated reasons, and you've got to say why it is that you're using it. The data that you collect has to be adequate, relevant, and limited to the purposes that you've stated. So, for example, if somebody's buying something from you that involves you sending it to them, then obviously you're going to need their address. And the reason that you need their address is so you can send it to them. So that's a stated purpose, and that's quite clear and nicely defined. But you're not then free to use that data for something else that's unrelated. For example, you can't bombard them with direct mail afterwards if you hadn't said that you were going to use it for that in the first place. You shouldn't store data longer than is actually necessary. So say, for example, you sell somebody something and it has a 2-year guarantee. It might be reasonable for you to keep that information for those 2 years so that if they come back to you, you can fulfill the terms of the guarantee that you offered them. You need to process data so as to protect the accuracy, integrity, and confidentiality. This is really down at the lower level, the security layer, making sure that you use TLS, that you encrypt data when you can, that you don't use plain text passwords, that you have just strong processes in place to handle the data. Now, up to this point, this is exactly the same as the previous data protection directive. So GDPR didn't change any of these things. The only thing it did change is this last one, which is that you must be able to demonstrate compliance with these. At any time, an information commissioner can come along and ask you specifically, why do you have this piece of data? Why is it here? Why have you still got it? On what basis are you holding it, and so on. And they can hold you responsible for that. So you need to be able to audit the things that you're using your data for. And all of these apply to both controllers and the processors. But then, what are the rights of the data subject that you're holding the data about, and that those principles are meant to uphold? Well, the individuals have, or our data subjects like you and me, they have a whole chapter for this, GDPR Chapter 3, Articles 12 through 23. And there's a nice little progression of 4 of these. The first thing is that you have the right to be informed. If a company is handling data about you, your personal data, then they need to tell you that they're using it. As a consequence of that, you might want to know what data it is that they are actually holding on you. And so that, again, is one of your rights. And one of the things that's quite likely to happen is that when you see your data, you're quite likely to see that there's some problem with it. And so, not surprisingly, you also have the right to correct inaccuracies. So, for example, if they've spelt your name wrong, or they've got your old address, or something like that, you have the right to require them to update that information. Finally, in that sequence, you have the right to demand that your data be erased. And this is also known as the right to be forgotten. Now, this one is actually slightly difficult because there are some circumstances in which it's actually very difficult to erase the data. So perhaps you should avoid getting into that situation in the first place, but there may be historical reasons that the data exists. And it may actually be practically difficult for this stuff to happen. For example, if data has been spread over a very large number of different places. And now there are another few rights which are more kind of technical and slightly less obvious. One of these is that you have the right to restrict processing. Now, this is a slightly technical one, really. So say, for example, that you as a data subject have told the controller that there's something wrong with the data they're holding on you, but they're not entirely sure whether they believe you. You can demand that they restrict your processing, that they stop using your information for the minute until that has been resolved one way or another. You also have the right to move data. It's called data portability. And this is actually a requirement in GDPR that you make machine-readable downloads. And this is typically done using formats like CSV, XML, and JSON. And the idea there is to try and prevent lock-in, to allow people to move their data from one service to another. You also have the right to object to certain kinds of processing, and most obviously of those is profiling. And this is why a lot of these ad pop-ups that you get are asking you whether you allow personalization of ads, because that is what profiling is. Now, fortunately, although some of these rights might seem difficult, they're actually, generally speaking, really quite easy to automate. It's really simple. If you've built a web app to allow people to log in and see their own data and amend it and even delete it, and possibly to do things like restrict processing. So we've been talking about data. So what is the definition of this data? Well, GDPR has a straightforward definition of a thing called personal data. And personal data is simply data associated with a person. Now, one of the things that often gets mentioned, but is actually kind of wrong, is this thing called PII, personally identifiable information. This is not a thing under GDPR. And it never has been, as far as I'm aware. I'm not entirely sure where the term came from. I think it's come from the US. The reason for this is that there may be something that's not personally identifiable information, but is still personal data. So say, for example, you're storing somebody's favorite color. The actual color value itself is in no way identifying. It's just an RGB hex code. It's not identifying. However, if that is associated with a person, it's personal data. So it's a very straightforward thing. And it even applies to fields that are individually encrypted. Even though that data is encrypted, if it's linked to an identifiable person, it's still personal data. If the entire person is encrypted, that could make things a little different, because at that point you may not be able to associate it with a person. Or say, for example, you only associate it with a hash of some identifier that you don't actually hold. For example, email addresses. It's entirely possible to store data that's not about people, effectively. GDPR is only concerned with people. It's not bothered about any other kind of data, not on companies, on weather tracking, or anything. It doesn't really care. If it's not associated with a person, GDPR doesn't care about it. So GDPR actually divides things up into three rough categories. There's the basic stuff that I mentioned already, just straightforward personal data. So this is the stuff you expect, and the things that are commonly stored in normal web applications. So people's name, address, phone number, and those things are directly identifying very often. But then some other things that are slightly less usual, things like IP addresses are considered personal data. In fact, they're considered identifying as well, so that's something to be careful of. Cookie values, as any pen tester will tell you, things like browser fingerprints can often uniquely identify people. There are all sorts of tricky things that allow you to be identified, and it's actually quite difficult to get away from those things. Now, one of the things that you can do to try to get away from identifying people is to pseudonymize the data. This is a difficult word to pronounce. But you can do things, as I've suggested before, like hashing emails, truncating IP addresses, anonymizing data in various ways. But this is actually really quite difficult to do due to something known as the mosaic effect. Say we take IP addresses, for example. Say we have one data set where, to try and hide the identity of the people in this data set, we truncate the last 16 bits of their IP address, and we store that data set. Now, there's some other data set where they've done the other 16 bits. You put the two data sets together, you have now re-identified all the people in that data set. And that's a problem. This is called the mosaic effect. And there are companies that will specialize in doing this for you. You can just keep feeding them data, and they will try and make all these records line up. So say, for example, they've got a phone number from somewhere, and an email address from somewhere else, and somebody's name, and their address, and location. And they try and put all these things together and assemble huge profiles. And a lot of the ad industry relies on services like that, and they're really quite creepy and insidious. The last thing here is the special category data. If at all possible, you should avoid anything in this category. If you don't have to process any of these things here, so health data, political affiliation, sexual orientation, anything that's remotely sensitive, you should avoid processing it if at all possible. Probably, genetic data is one of the worst things, because if that leaks, there's no putting it back, and you can't escape from it. You know, you might be able to, if it's your email address, you might be able to change your email address, for example, but you can't change your genetic makeup without some kind of sci-fi thing. So if at all possible, you should try and avoid that. Something I mentioned in the middle here is differential privacy. This is a really clever way of hiding identities. The idea is that you, instead of anonymizing individual records, but you still have this correlation of a single real person to a single real record, you add noise to your data. You add additional records that are invented people, that are invented records. But you do it in a way that doesn't upset the overall balance of the real data. And the idea here is that you can still then make aggregated statistical and meaningful, useful measurements from your aggregated data set, but without having to reveal the identities of the people inside it. So if you look at any individual record, you might not be able to tell whether it's a real person or an invented one, but that's the point. You can then dilute that information. It helps stop re-identification. One of the problems here is that sometimes this mosaic effect might be quite subtle. So say you've got somebody called John Smith that lives in London. It's fairly likely that it's going to be very difficult for you to identify that person. However, if you've got a John Smith that's in Ulaanbaatar in Mongolia, there probably aren't that many of them, and it shouldn't be too hard for you to be able to re-identify that person. So there are sometimes things that are not obvious that allow re-identification of people, and that's where differential privacy can help, by just adding noise and preventing that re-identification. Apple has been heavily into this in their health tracking and the Apple Watch software. They've done a lot of health research with like heart rate monitoring and things on a very large scale, and they've been diluting it by using differential privacy to avoid exposure of this type. So one of the things I mentioned earlier in the principles is that you need to have a stated purpose for doing this. And it turns out there's a whole set of these that are nicely defined in Article 6 of GDPR. The first of these is something I've actually alluded to already, which is that you might need to process data on the basis of a contract. The most obvious one of those would be somebody who buys something from you. When you make a sale, you offer a service or a product, they respond to that and accept it. That establishes a legal contract, and you can process their data on the basis of that contract. So that's really quite straightforward. There may be a legal obligation for you to store data on somebody. This, for example, is something that's actually true in the UK. Employers are required to store information about employee liability insurance for 40 years, and that's largely in the wake of things like asbestos exposure claims from the 1970s. You might store data that's in the vital interest of a person, like something that might be critical to their survival. Now, this is really only applied in sort of life or death situations, and it also applies to people that don't necessarily have any kind of established relationship with you. If you know this information and it may be of use in order to helping that person survive, then that's your basis for processing, and it's fine. You don't need to worry about some kind of exposure on that. Similarly, on a larger scale, public interest. If something is of overwhelming significance to the public, like they've got some nasty infectious disease because they haven't been vaccinated, it's perfectly reasonable for you to expose and handle that data without being too concerned about whether it's legal or not. Now things get a little bit trickier, and the worst of these really is this next one, legitimate interest. And to a large extent, this is how ad networks work. They kind of go, well, our company is based on taking your data and selling it to people. Therefore, that's our legitimate interest for the operation of our company, so we're allowed to do it. Now, that's not on, and although strictly speaking, that's really in the realm of the e-privacy directive, which is actually due to be replaced in much the same way that GDPR replaced the data protection directive, but that hasn't actually happened yet. It's been a bit slow. It's been held up in debate. But there are perfectly good reasons for using legitimate interest as your basis for processing, and probably the most common one of those is things like fraud detection and anti-money laundering requirements, although that might also come under legal obligation as well. But it's important that whatever the legitimate interest that you use, you must preserve that original justification for it. You can't then expand it. There's been a really good example of a really bad use of this by Facebook just recently. They had a mechanism whereby you could use your mobile phone number to send you an SMS to use as a second factor for authentication. That's a perfectly good, legitimate use of legitimate interest. Perfectly reasonable. What isn't reasonable is the fact that they then made that phone number searchable and sold it to advertisers. That's really bad, and I see bad financial things for Facebook as a result of that. And the last one, which is probably the first one that you thought of, is consent. And the reason I put it last is that consent is actually quite tricky. You should only use consent when processing would otherwise be illegal and it is not covered by any of the other bases. As the data protection principles say, this must be done fairly, transparently, and proportionate to its use. So, for example, you don't want to have a checkbox that says, yes, you can remove my kidney. You need to do something, you need to be a little more certain about questions like that. You need to make sure that this permission is obtained before the processing happens, not after. So if somebody visits your site and you're asking them to set cookies, don't set the cookies until they've answered the question. And that's something that you see broken all the time. So that's to be avoided. Essentially, if data subjects don't know or understand clearly what it is that they're agreeing to under the consent or legitimate interest bases, then it's considered invalid. It's as if you had not asked. And so that means that you may be fully liable for the fines that may be heading your way as a result. Now, the problem with this is you get a lot of attitude coming from companies, particularly those that are based on ad revenue, where it's all really as a result of exploiting personal data for their own financial gain. An example I saw recently is someone saying, well, what's the difference if you go to your doctor and you give them some personal data versus you go to Google and you give them some personal data? Well, the difference is that your doctor uses it directly to give you a diagnosis and to help you deal with a specific problem that's personal to you, and they don't give it to anybody else. Google provides you with services. You give them data. They sell that data to their advertisers who pay them, which allows them to then offer you the service that you're using. But you're paying for it with your data. And that's not something that your doctor is doing. So Facebook will say things like this, which is exactly as expected. Be under no illusions. Effectively, Facebook is the enemy of privacy. And all this recent press, just the last couple of weeks, Facebook and Google have been all over this thing about how they're supporting privacy in this amazing way. One of the problems here is that the way that a lot of these companies are lobbying in the US is really trying to make it that they're saying privacy means that they don't share your data with other people. That's not the case at all. Privacy means them not having the data in the first place. And that's how it's defined under GDPR, but they're really trying to bend it because the US is under quite a lot of pressure to implement better privacy controls because there's been such a long history of abuse. And quite a few states, particularly California, are trying to kind of take their own action on this and implement their own laws that support this. And so this really leads to this quote, which applies in lots of places, but I really like it. Now, I have a feeling that some of your databases might look a bit like this. And many of us are guilty of hoarding data, resulting in these ever-expanding data stores. Scalability, woo! But this data is very often toxic. If it all was leaked in a data breach, that will be a really serious problem for you. And the best thing to do is to get rid of it. Don't store stuff. Back in the principles, we saw one of the things is that you only keep data for as long as that's actually necessary. Don't hold on to stuff. Many marketeers will go, just like, more is more. You know, we want more people on our mailing list. We don't care how long they've been there or whether they actually buy anything. We just want more, forever. This is not reasonable. And because of that, this is why GDPR is not like other standards, particularly technical ones like HIPAA and PCI. It's not something that you can outsource. It's something that requires a cultural change in the way you go about things. So carrying on with data breaches, this background here, I don't know if you're familiar with the Have I Been Pwned website. Go there, put in your email address, and you can find out all the public data breaches that you've been in. It's a really good service, and they've got some other excellent services related to checking passwords too. GDPR defines data breaches in Articles 33 and 34, and the most important definition really is that it's exposure of data likely to impact data subjects. Now, that doesn't necessarily mean that the data itself is particularly sensitive. Merely its context might be enough to be damaging. And a good example of that was the Ashley Madison data breach. That was pretty bad news for quite a lot of people. All it had to do was reveal their names, and that was enough to cause some major disruption, and even a few people killed themselves over it. These things can be really significant. You need to report data breaches to your host country supervisory authority, which is usually the information commissioner. You need to do it within 72 hours of discovering a breach, unless the data was encrypted. And the reason for that is that if the data was encrypted, then the chances are it's unlikely to impact the data subjects. So encrypt stuff at rest if you can. If your data breach includes special category stuff, then you are required to actually notify the data subjects. And notify that there's an implication here that if it doesn't contain this kind of data, then you don't necessarily have to reveal it publicly, but you may still need to reveal it to the public authority. There are fines for breaches, but there are also fines for not reporting breaches. So you could get hit twice for the same one if you have a breach and try and cover it up and get found out. So to cope with all this stuff that you need to think about, there are different roles and responsibilities. And one of the things that you have to do is retain records of changes in your personal data processing. And that might include simple things like keeping previous versions of your privacy policies. And you can use Git for that. It's great. Now, when you do some of these things, you might actually want to establish why it is that you chose to do things in a certain way. And when you do that, commonly you would execute one of these things, which is a data protection impact assessment. And similarly, there's a thing called a privacy impact assessment, which is more or less the same thing, just pitched at a higher privacy level. And a scenario that might relate to a data protection impact assessment might be, does this change to a system impact a user's ability to see their own data? For example, if you've imposed two-factor authentication, but some people are having trouble using it, for example, that might be something that you need to address. Privacy impact assessments might be something like, hey, we've got this idea. We're going to show people's phone numbers of people that are logged into the website. And your immediate thought might be, that's a terrible idea. It's like, well, it would be if it was a completely public site, but it might not be. So, for example, this is a website that presents contact details for emergency contacts, in which case that would be entirely appropriate. But at some point, you may be required to produce these. You may be required to show a document which reveals your thinking. This is something that Martin Fowler touched on in his talk yesterday about keeping records of why you chose to do certain things, why you chose to do things a certain way. And you can do either of these assessment types at different points. You can either assess a system in its entirety, or you can look at an assessment of a change that you're proposing to make. You might need a data protection officer as a person to do all this, and you don't necessarily need one, but you will need one if you are a public authority, someone that tracks users a lot, or that you handle special category data, and you can possibly outsource that. This says I've run out of time. This says I've got 3 minutes. Okay. Okay, now, as developers, there's a last thing that's important, is this concept called privacy by design. This is a set of 7 principles, first defined by someone called Anne Cavoukian in 1995. She's a prominent data protection campaigner and an information commissioner in Canada. And it's now made its way into GDPR. And there are 7 of these principles. The first is that you should use privacy as the default. So if you do nothing, data should remain private. That's a pretty straightforward thing, and it's actually pretty powerful. A lot of systems don't do that, so it's a good place to start. You should be proactive, not reactive. Try and anticipate and prevent privacy-invasive events before they happen. You should aim to do things to provide full functionality. Very often people go, we can't do that because privacy. What you should really do instead is say, well, how can we do this thing while preserving privacy? Think of it in more of a positive way. You need to think about end-to-end security, the full life cycle of the data, from the point where it enters your system to the point where it's deleted, not just simply from moment to moment during TLS connections, for example. All of this needs to be transparent. That's one of the things that's required in the data protection principles, that you need to be able to understand how it is that you're handling stuff yourself. And overall, keep stuff available for, respect the user's privacy. Make stuff accessible to the individual data subjects. And finally, embed the privacy into your design. Build privacy controls into your tools, your frameworks, your processes, and your deployments, so that you can do kind of compliance as code. Just as you do things like inline documentation and unit testing, build privacy stuff into your tools in the same way. I'm working vaguely on a Laravel extension that allows you to build this kind of additional metadata into the framework itself so that it's possible to do things like query your code base and say, why are we storing this information? Or query your database and say, how many people are we storing past the date where we said we would delete their data? So that's pretty much it. There's a ton of GDPR resources online. You can get the full text of the GDPR itself from the European Parliament website, but this version is not an official one, but it's much easier to read. The information commissioners have websites. There's the Irish and French ones. The UK one is quite nicely written, but is increasingly becoming irrelevant with Brexit. There are law firms which obviously have lots to say on laws like this, and they produce blog articles which are often very informative. The Privacy Shield list, you can go and look up US companies to find out if they've registered for this scheme. And not surprisingly, there's a ton of people on Twitter. So to wrap it up, you need to know your data principles, be aware of the rights of your data subjects, understand the distinction between controllers and processors, understand what personal data is, understand the basis for processing and select one that's appropriate for your use, and practice privacy by design. And do all those things together, then you can be a privacy superhero too.
Okay, we have time for answering a few questions, maybe one or two.
Do you think it's legitimate usage of personal data if a company forwards information about developer team members to the customer? Employee-employer relationships are something that I'd expect to be covered either by contract or by legal obligation. And it's recent that the employer-employee thing is something that has lots of other laws that are not GDPR laws associated with it. Now, if you left the company, after that, GDPR will become much more relevant, but there's employment law that's much more tightly defined than the things in GDPR, which is much more about interactions with the general public than it is between employee and employer. Next one. Do you think there's an alternative to behavioral advertising model big companies are using? An advertising technique that's both effective and respects privacy. There's nothing wrong with advertising. It's the targeting, the behavioral analysis, and the tracking that goes with it that's the problem. Advertising existed very successfully for many, many years without doing any tracking at all. Sure, it wasn't as efficient and focused, but it was also much, much less invasive. If you look at things like TV advertising, which is just plummeted because of basically the fall in TV viewing. And similarly for things like print advertising. That's become a problem. It's hard for companies that are financed by ads to be able to do this stuff. So obviously the tighter they can focus their advertising, the better, and you can see exactly why they want to do it. However, somehow they need to figure out a way of doing this in a way that's not so privacy invasive. I'm not entirely sure what it is, but things like micropayments, like the Brave browsers trying to push, and actually paying for services, and that's what I do with my own services. People pay for us to use our stuff, and that's it. We have no ads, no cookies, no tracking, nothing. Even though my system does email marketing, it's entirely possible to do that kind of thing without having to rely on invading privacy that way.
Our time is up, sorry.
Okay.
So, but Marcus will be here all day, so you can go there and
yep, you can
just
come and talk
ask
to
your
me.
questions. Thank you so much for your wonderful presentation. This is a little gift from the organizers team with a picture of you. Thank you so much.